Reminds me, I feel like back in my school teaching days when I would tell my class good morning, and it was usually, it was the only response I got. Call the first case, please.
Robert Elmore versus Travis L. Mills, CRNA et al.
We'll hear from the appellate when they're ready.
And Your Honor, I'd like to reserve 4 minutes for rebuttal.
4, that'll be fine.
May it please the court, I'm Megan Culver here on behalf of the appellants Dr. Sorcy and Tennessee Valley Orthopedics LLC, who you'll probably hear me refer to as TVO throughout this argument. As your honors are aware, it is an interlocutory appeal which this court certified 2 issues. The first issue being substantially similar to its companion case that was decided by this court in October of 2024, whether or not the trial court erred in determining that the statute of limitations was July 5th of 2020 and therefore pre-suit notice was timely filed. Even though that opinion is not binding on this court, and in the order explicitly said this only pertains to CRNA Mills and Lakeway Regional Anesthesia Associates, it is persuasive authority, and some of the opinions that came out that I think are helpful in this case. For one of the issues in this case was we were arguing over whose knowledge controls. We had contended under Holloman it was the plaintiff's knowledge because it's a wrongful death case rather than the decedent's knowledge, because the plaintiff stands in the shoes of the decedent in a wrongful death case. Appellee had consistently asserted that it was the decedent's knowledge who controlled. In the order in the companion case that came down in October 2024, the court said it is the decedent's knowledge that controls. And while it respectfully disagreed with the trial court that July 5th, 2020 was the triggering date of the statute of limitations, it still could not say that the statute of limitations had expired on the basis of the complaint as to CRNA Mills and as to Lakeway Regional Anesthesia Associates. I do think, though, the argument is still viable for Dr. Sorcy and TVO, because when you look at the complaint, there's approximately 11 paragraphs of allegations against Dr. Sorcy, one of which has 13 allegations in the subpart, which is paragraph 46. Compare that with CRNA Mills, which is mentioned approximately 4 times, and Lakeway Anesthesia Services, which is mentioned approximately 2 times. So compare about 24 paragraphs for Dr. Sorcy, 2 paragraphs for TVO versus about 6 paragraphs for CRNA Mills and 2 for Lakeway Regional Anesthesia Associates. Talking about what Dr. Sorcy did through all those paragraphs, which starts at paragraph 9 and goes through approximately 16 in the complaint, talking about how he ordered that Mr. Elmore, the decedent, was to be NPO that day, but decided to go to surgery anyway, and then an aspiration event occurred, causing the decedent to be transferred on June 21 of 2020. The discharge, that's in paragraph 34 of the complaint. The discharge diagnoses per paragraph 34 of the complaint were aspiration pneumonia, which is one of the causes of death listed as a cause of Dr. Sorcy's alleged actions in paragraph 48. Now, as your honors are aware, and I'm sure my clients would agree, simply because there was an adverse outcome doesn't necessarily mean there's a claim there. However, using the reasonable person standard, if all these dates in the complaint stop after June 21, 2020 against Dr. Sorcy, who TVO is purportedly, allegedly vicariously liable for, then under the reasonable person standard, you should have known that the claim arose no later than June 21 of 2020.
As I recall, in the first case,
yes, Your Honor,
I thought we held that whether or not the plaintiff was aware.
Yes, Your Honor, you did.
Okay.
Yes, Your Honor.
What's in the complaint that shows that when the plaintiff was aware of this?
Yes, Your Honor. I don't think there's any overt phrase that says the plaintiff knew on X date, and in some complaints you'll see that.
At least what we held was there was nothing in the complaint showing when the plaintiff.
As to CRNA Mills and Lakeway Regional Anesthesia Associates.
I mean, under your position, every time a patient died, the statute of limitations would start.
Respectfully, no, Your Honor, that's not what I'm saying, because cases have been clear. It is a discovery rule as to when the injury occurred and if there's later on a death. We agree with that, Your Honor, but we're saying while the plaintiff's complaint, because in some cases, as I'm sure you've seen, it says, well, we couldn't have discovered it before X date because of these factors. We don't have that here. It also doesn't say plaintiff talked to anybody, but under the reasonable person standard, he should have known based
Why?
on all these allegations.
Why? How do we know that? What the plaintiff should have, maybe the plaintiff was an uncle out in Oregon
Sure,
and didn't get contact. Maybe the plaintiff is nobody related to the decedent, but got to be appointed executor of the estate for some reason. I mean, what was in the complaint that gave us anything? And as I recall, we left it kind of open, so we didn't say for sure. We just said that what was in the complaint, this motion to dismiss stage, there's nothing there indicating one way or another when the plaintiff even got involved in this lawsuit.
Yes, Your Honor, I understand. In oral argument in the trial court below, it was relayed that the plaintiff is a relative of the decedent on page 359, so we at least have that. He is a relative. However, again, just following under a reasonable person standard, there are no allegations after June 21. If you're going to allege he died due to the same events that occurred on June 21, 2020.
There would never be any allegations after a patient's death that something was done wrong.
Well, at June 21.
Is that correct? After a patient's death, there would never be any allegations that the healthcare provider did anything wrong that caused the death after the death.
Well, yes, Your Honor, but he didn't die on June 21, 2020. He died on July 5th of 2020. June 21, 2020 is the transfer date to another facility.
Okay, let me suggest you might go on to issue 2.
Yes, Your Honor. May I make one brief moment, and then I'll get off the statute of limitations. Pre-suit notice was sent on July 2nd of 2021. In the complaint, July 2nd of 2020 was listed as this is the date the providers decided nothing more could be done for the plaintiff. Our issue with using July 2nd of 2021 as the statute of limitations, as suggested by sending the pre-suit notice on that date, is that it relies on the advice of a medical provider, which isn't required under Stanberry versus Picardi. Moving on to issue 2, Your Honor. The second issue before this court as to Dr. Sorcy and TVO is whether the trial court erred in determining that substantial compliance was met in this case. We respectfully assert that the trial court did err because of the burden-shifting approach under Martin. As to the first prong under Martin, it is the appellee or the plaintiff's initial burden to attach documentation to the complaint evidencing compliance. That would be as also required as 2926-121B. Our issue with the documentation is that to date, there still has not been any production of a signed HIPAA authorization for the HIPAAs that are missing, for the HIPAA authorizations in this case. The one for TVO to get records from Jefferson Memorial, Dr. Sorcy to get records from CRNA Mills, and there's still the issue of the missing authorization for Dr. Sorcy to get HIPAA authorizations from Tazewell Arthritis and Orthopedic Clinic, which was a provider sent notice in this case. And under Travis versus Cookeville Regional Medical Center, which we relied on in the trial court and the appellee has cited in this case, the court found that there was no compliance with 2926-121 when after he was given time to amend to put the documents assigned HIPAA authorization in, he didn't do it. That's why we're saying the initial burden was not even met in this case. And as you'll see in the record before this court, there are 3 unsigned HIPAA authorizations as to my client. Nonetheless, even assuming the burden shifted to us, we met that burden. So what under Martin says is that we had to file a motion to dismiss. We did that. And then we were to demonstrate that the noncompliance resulted in prejudice by explaining, for example, how the noncompliance frustrated or interfered with the purposes of Section 121 or deprived the defendant of a benefit Section 121 confers. And the Tennessee Supreme Court in Martin said one way to do that is allege or show that there's a missing core element. In 3 of the HIPAA authorizations, Dr. Sorcy to get records from CRNA Mills, there's a missing signature and there's a missing expiration date. Those are 2 core elements under HIPAA regulations. There's a completely missing one for Dr. Sorcy to get records from Tazewell Orthopedic and Arthritis Clinic, which was a provider sent notice, and then TVO to get records from itself, completely blank as to signature and expiration date, and TVO to get records from Jefferson Memorial Hospital, blank as to signature and expiration date, all of which are core elements. Therefore, we did meet our burden because without this court the Tennessee Supreme Court in Martin held that when the HIPAA authorization is not fully filled out, it's been found compliant in very few circumstances. One of them being Hamilton versus Abercrombie Radiology, where the signature and the date the date was not filled in with the signature. That was just one, but it didn't affect the materiality of the HIPAA authorization itself.
Did the plaintiffs present anything to the court showing that your clients did not suffer any prejudice?
No, Your Honor, he never filed any discovery responses. He never had an affidavit that said, oh, these records, that Tazewell didn't have records, that CRNA Mills didn't have records, Your Honor.
So after the burden shifting, after you presented to the court that the HIPAA authorizations, some of them at least, weren't satisfactory or weren't compliant, that they presented nothing showing the court that despite that, don't worry about it.
Okay.
Despite that, your client still did not suffer prejudice.
That is correct, Your Honor, and that's what we're saying that the record shows before this court. They've asserted here that Tazewell Arthritis and Orthopedic Clinic didn't have records and was merely listed as a registered agent, that Dr. Sorcy was listed as a registered agent for them. That's why they were named. That proposition was rejected by this court in Russ versus Jackson Surgical Associates because they inadvertently named Bolivar Hospital because it was listed as a registered agent for the proper hospital. This court said it doesn't matter that they didn't have records. You named them, you got to send it to them. They've also tried to rebut that the patient, by virtue of being a patient of Dr. Sorcy, he could go in and get the records by himself. However, in Winsler, which was a case cited by the appellee, this court held, no, you can't do that even under HIPAA because that doesn't cover under healthcare operations. So in sum, Your Honor, there's nothing before this court showing that CRNA Mills didn't have records, just an allegation. There's no affidavit, there's no other evidence. At most, they pointed to discovery responses, which the trial court said in 2 orders that are in this record before the court, it didn't consider them because they were never filed before the motion to dismiss. So yes, Your Honor, we're saying there was nothing presented.
Thank you. You have your time for rebuttal.
Thank you, Your Honor.
We'll hear from the appellee.
Good morning. May it please the court. Christopher Gilreath for appellee Robert Mills on behalf of the estate of Lonnie Mills. The very key issue in this case was presented at first, whether or not the trial court erred by denying the appellant's motion to dismiss. The trial court did do a proper analysis. This was a Rule 12 motion that the trial court faced. Based on the original procedure that was set out by the Myers case and then affirmed by the Stevens and then the Martin case. And so the court did what the court was supposed to do. It was to look at the pleadings. When you deal with a Rule 12 motion early in a case, there's always an issue about whether or not you're even going to get into discovery. There's been some debate in the Court of Appeals, first in the Reese versus Waters of Clinton case, and then much later now in the Hayward versus Erlanger case, where there's an issue about whether or not discovery is an appropriate tool to use in analyzing situations like the one we have this morning. The court has most recently, in the Hayward case, says that yes, discovery is relevant to be able to show prejudice, or if there is any. and that is a relevant inquiry. Why? Because Martin tells us that this court is supposed to, and the trial court is supposed to review not just technical missteps that may befall a pre-suit notice and medical authorizations, but also the extent and the significance and the impact of any missteps or any failures of those authorizations to be fully complete. And in this particular case, there actually is some discovery material that's in the court record. The trial court did its very best, being faced with, and this is Judge Ogle, who's a wise, studied trial judge, been on the bench for 30 years at the point that this case was heard. And he knew that faced with a Rule 12 motion, he was not supposed to consider a whole bunch of discovery. He was supposed to rule on the pleadings, and that's what he did. If you look at the Martin case, Your Honor, the court asked my colleague, did the plaintiff present any evidence to the trial court of prejudice? And if you look back at the trial court transcript of the hearing on this motion to dismiss, which is in the record, the trial court very specifically raised the issue of prejudice. Now, if you look back at the structure of the Martin case, the burden of showing prejudice actually falls on the party moving to dismiss, in this case, the appellants. Now, of course, both sides would have the opportunity to show either the existence or the absence of prejudice. But in this case, the trial court found that there was no prejudice.
Well,
And
hasn't our Supreme Court said that if the HIPAA authorization was not compliant, certainly one of the core elements is missing, that's prejudice? That shows, didn't they say that's one way to show prejudice?
It is one way, but Your Honor, it would not be consistent with the Supreme Court and the rulings of this court to find that a technical problem with an authorization is per se prejudice. That approach was adopted in a few of the earlier cases, but it has been kind of, the court's thinking has matured past that point. The Martin case is the Supreme Court decision that essentially resolves that question, because there was the Martin, in fact, there was a previous case, Buckman versus Mountain States. I believe that was a 2018 case. And yes, that was a case where the filing plaintiff had provided some pre-suit notice on authorizations. The authorizations were deficient in some ways, and the court, following the Roberts versus Prill case, which was a 2014 case, essentially adopted this idea that if there was a technical violation, then that meant there was per se prejudice. Therefore, the plaintiffs did not meet their burden under the statute. Case must be dismissed. Martin abrogated the Buckman case, expressly said that it abrogated that case. And this is, the Martin case is from the Supreme Court. That is the case that established that the court said, no, you are supposed to not just look at the actual missteps, the actual errors in the authorizations. You're supposed to look deeper to the substantive impact, the quantity, what's the nature of the deficiencies? What is how did those deficiencies interfere with the ability of a treating provider to be able to access records? And it's the same reason that cases like the Bray case, the Wensler case, and most of the cases that have occurred that this court has ruled on since Martin have looked to that substance and have gotten into the nuances of, well, what exactly was the nature of the violation and what impact did it have? It deals, in Bray, that was the so-called one defendant exception case that the Supreme Court issued. And that case was important, not necessarily because we have a one defendant situation here, but the Bray case did two things. First, it said when you have one defendant, that one defendant doesn't have to have been given its own authorization. And that the second thing that transcends that exception is the Supreme Court's recognition that the HIPAA privacy rule expressly says that the only time you have to give authorizations is when it is to another provider. The Supreme Court adopted HIPAA's language that said, we see that within the course of the HIPAA privacy rule, you don't have to give an authorization to yourself to use your own records. That recognition transcends Bray and really applies to any healthcare liability case in this situation, even though the courts, when looking at the functional effect of authorizations, will consider the Bray case to be the one defendant exception, which still applies. But Bray carries two important points to it, and I thought that was important to bring out to the court.
Do you agree that there's, or disagree that there's still this burden shifting? I always love it when the courts come up with a burden shifting. But this burden shifting process, starts here, goes here, and then, starts with plaintiff, then goes to defendant, then back to plaintiff.
Yes, Your Honor.
Is that still the path to be followed?
From everything I can see, Martin, the kind of the scaffold that Martin created around this issue, I think is intact. And it's actually the approach that Judge Ogle used in our case.
Well, did you present any proof to the trial court showing that these defendants did not suffer any prejudice because of if the HIPAA authorizations weren't compliant, because they were missing some of the core elements?
Yes, there was a debate in the trial court about whether or not we raised the issue of the fact that the appellants in this case did not even attempt to use the authorizations.
That hadn't been much help to plaintiffs in the past.
Correct. In this case, and it's contained in our appellate record, there is evidence that the appellants never requested records or attempted to request records with the authorization because they already had them. In this case, the hospital had provided the appellants with a copy of the case before the notice ever went out.
I mean, is that all in the record?
It's in the record.
Showing that they had the records, all the records?
It's not that explicit, Your Honor, to be fair. The reason that we're arguing this case today instead of a year and a half ago is because the parties ended up engaging in a back and forth about attempting to amend the trial court record, because there was discovery material. In this case, the discovery is not filed with the court. There was an attempt to propound discovery and get responses. Before that process was fully complete, the court heard the appellant's Rule 12 motion. And so we used what we had. And in this case, and one thing that the Bray case and the other cases are helpful to kind of patch things together is that in this case, the only set of records that was involved was a hospital record from Jefferson Memorial Hospital. The appellants received a fully valid HIPAA authorization from the appellees, allowing the hospital to provide records to the appellants. And so whether or not the appellants went out and requested records as any kind of citizen would, or whether they got them informally, the authorization they received allowed the appellants to use the records that they had. And it's also important to note that if you look back at here's the purpose of 121 is to create a structure amongst any healthcare case that would occur in Tennessee, is to provide a vehicle to make sure that treating providers, hospitals, are granted access to records in the case there is a dispute about a healthcare incident. The statutory scheme adopts the assumption that under the HIPAA privacy rule, generally a medical provider must be granted authorization to access records. However, if you actually look at the HIPAA privacy rule, there are a lot of circumstances where treating providers are granted explicit access to those records without an additional authorization. And the statute, doesn't pick and choose whether or not it's a one provider situation or a 10 provider situation. The reason it matters here is because we have one source of records, that's the hospital. We have a small number of providers. All of the jurisprudence that this court has issued and the Supreme Court has issued, the fewer the number of treaters, the simpler the analysis has been about whether or not there was prejudice, whether or not there was access. The Wensler case, for example, is a case where you had a dentist and a dental practice that technically employed the dentist. And the issue was whether or not the dentist and the dental practice, had to give each other access to records. The Bray case, again, single medical provider, no need for an authorization there. Lots of other cases where you have providers that are not connected in practice together, yes, you need authorizations there because those providers are not affiliated with each other. HIPAA says you must provide access. But the HIPAA privacy rule 164-506 explicitly allows for disclosure of private health information when you have treating medical providers that each have a relationship with the patient, which is exactly the situation in this case. Explicitly under that HIPAA privacy rule, as long as it is for treatment operations, payment operations, or so-called healthcare operations, authorization is already granted by the fact that that relationship is there, because the privacy rule was never intended to block treating providers from having access to records of care in the relationship with their patients. It was designed to block external invasions into a patient's private information where the patient had not said, I want you to have access to my information. And so whether or not, in this case, not only does HIPAA expressly grant the appellants access because of the relationship between the patient and the providers in this case, but the actual authorization, and if you look back at all the cases, they focus on the authorization that blocked or did not block access to the records in question. In this case, it's records from Jefferson Memorial Hospital. In this case, there was a valid authorization that the appellants had. They got access to the records. There was no prejudice. The trial court found no prejudice. There was no evidence presented by any party as to prejudice. And because of the small number of missteps in those authorizations, the fact that the ones that were involved had no impact on actually providing access to records to the appellants, there is no prejudice, and we ask the court to affirm the trial court's decision.
Thank you. Here from the appellant rebuttal.
I'll start with the discovery. There was a lot of what should be and should not be in the record in this case, and the trial court held in its order, which is on page 651 of the supplemental technical record in this case, the record shall not be supplemented, and the following materials requested by plaintiff shall be stricken from the supplemental record, which was the discovery responses, because the trial court never relied on them because they were never filed before. Nonetheless, as to that both appellants had access to the only relevant records, which were Jefferson Memorial Hospital. First off, our allegation in our motion to dismiss and appear is that TBO never received a signed HIPAA authorization or one with an expiration date to get records from Jefferson Memorial Hospital. It's nowhere in that TBO already had those records. Furthermore, as to...
Under, what is it, CFR 164-506, did your client Did your client was your client authorized to look at the hospital records?
For the hospital records, as to Dr. Sorcy only. TVO, no, because it's not a part of the hospital, Your Honor. TVO is not a part of the hospital. It's not affiliated with the hospital. It's a separate entity. So no, under HIPAA, it can't. That's why it needs the authorizations, and that's why we have all this case law. They're unrelated entities. As far as the allegation that it's only the Jefferson Memorial Hospital, this court rejected that allegation in Shaw versus Gross when the amended complaint said the decedent only treated the hospital because it was never proven, nor does that allegation standing alone prove that none of the other providers have records. That's the case here. We don't know if CRNA Mills had records. We don't know if Tazewell Orthopedic and Arthritis had records or not, because that was the purpose to serve as the investigatory function under Stevens to see whether or not they have records.
Now, the question is not whether or not they have the records. The question is whether or not they have the ability, already have the ability to see the records. Do you agree?
Respectfully, Your Honor, it is whether or not they have the ability to see, to go and request the records. We did not have the ability to go and request the records from CRNA Mills and Tazewell. We never got one for Tazewell Orthopedic.
I understand.
Mills.
My question, though, is whether or not without the medical authorization, did your clients have the ability to see the hospital records?
The hospital record alone, Jefferson Memorial Hospital, not any records independently held by CRNA Mills or Tazewell Orthopedic Alliance. No, they could not, Your Honor. That's why they needed the HIPAA, because they're unaffiliated entities.
I understand. Okay. And they have records that are not in the hospital?
We don't know, Your Honor, because we didn't have the HIPAA authorization allowing us to conduct that investigatory function under Stevens. And that's why we're saying under Hancock versus BJR Enterprises, per se prejudice resulted because they were facially invalid, because they're not signed. There is no case cited to this court that not signing a HIPAA.
I understand what you're saying, why they're not. My question to you is whether or not, as I understand, at least part of the plaintiff's argument is, your clients had the ability to see these records. They were treating physicians, or treating healthcare providers, and that what they could see was they had access to the hospital records. Now, maybe I'm misunderstood what he said, but that's what, so you didn't need an authorization. So the fact that the authorization may have been incomplete or didn't satisfy HIPAA didn't matter. Your client already had the ability to see these records.
Respectfully disagree under the case cited by, which was Winsler, which said that an employee of the dental practice could not go in and access the records and use them under HIPAA, Your Honor. The practice itself could use it, but the employee could not go in and access the records and use them, and that's what we're saying here.
Well, I wonder who was going to do it if an employee couldn't.
I don't know, Your Honor. That wasn't answered. I'm out of time.
I mean, the practice can operate through its employees, but
That was the holding in Winslow, Your Honor,
Yeah.
which was relied upon by the appellate. May I briefly just wrap
Well,
up? My time is
all
is over. Unless Your Honor has more questions, I'm happy to.
no, I hear none. This is the court thanks counsel for both sides for your briefs and your oral arguments today. But I will say this case is the latest in a long, long line that we've had these, and I, speaking just for myself, not for anybody else, I'm still puzzled why these traps haven't been addressed and taken care of. Because they catch the defendant sometimes too, as well as the plaintiff. But in any event, thank you for your arguments and your briefs, and those were my personal comments. And the Supreme Court and the legislature has paid just all the attention